Though not a foundational or formation document to the estate, one last document that has bearing on the estate is the death certificate. One consideration not often made by many is what happens to the estate when they die. Many are aware that it is a wise thing to have a will drawn up to ensure what happens with the stuff one collects throughout their life. However, given that so many are not informed of the existence of the estate, or the trading done on the trust and its amassed wealth, very few know of the need to perfect title of this asset prior to their passing. This can create a serious liability for the trustee holding the title in safekeeping. This liability comes from the appearance the trustee is attempting to arrogate the estate or other assets of the estate, that is, stealing assets or revenues, and by the refusal of the trustee to return the estate or other assets of the estate to the grantor upon the death of the sole beneficiary. This places the trustee in a very serious position. By law, the trustee may not, while the trust is in existence, give the estate and assets of the estate to anyone but the lawful beneficiary. These may not even be given to the grantor. To do so is a breach of trust. To cure this problem, and to ensure the estate assets are properly managed and disposition recorded by the trustee upon the death of the sole beneficiary, the deed of defeasance was employed, and called the death certificate. A defeasible deed is defined as a deed containing a condition subsequent causing title to the property to revert to the grantor or pass to a third party. Black's Law 9th ed. at 476. Defeasance is a term meaning 1. An annulment or abrogation, voidance. 2. The fact or an instance of bringing an estate or status to an end as by conditional limitation. 3. A condition upon the fulfillment of which a deed or other instrument is defeated or made void. A contractual provision containing such a condition, also termed defeasance clause. 4. Hist. A collateral deed made simultaneously with a conveyance and containing a condition by which the main deed might be defeated or made void. Black's Law, 9th ed. at 481. Before we turn to look at the death certificate more closely, we must comprehend the underlying purpose of, or use for, this deed. As the definition of defeasible deed sets out, this deed causes the title to the estate and its assets to revert or go back to the grantor. This is significant with regards to the estate, as the estate was placed into a passive trust to await its being properly claimed by the sole beneficiary. A passive trust is a trust in which the trustee has no duty other than to transfer the property to the beneficiary, also termed dry trust, general trust, nominal trust, simple trust, naked trust, ministerial trust, technical trust. See bare trustee under trustee, Black's Law Dictionary 9th ed. at 1652. Until such claim has been made and the grant perfected, the trust remains in place. The portion of the definition which reveals the application of the defeasible deed to the trust is where it states revert to the grantor. This is significant because the only time the grantor can repossess that which has been granted or gifted without consideration is where the gift or grant is imperfect, that is not accepted by the grantee, or the beneficiary has not been found. As many have never been told of the estate held in trust, or of the requirement for them to claim it, it often happens that the grant is never perfected. If the child passed before the parent, the death certificate reverts the estate back to the father, the grantor. However, if, as is the more common occurrence, the father passes before the child, the death certificate causes the estate and its assets to revert to a third party. A final consideration before we delve into the document itself. As revert means to go back to, this necessarily must mean the third party must be associated with the original grant. The only party so associated would be the ancestral line running from the child to the father to the grandfather, and so on. As we will see, and as the reader may have discerned themselves, the death certificate, as a defeasible deed, reverts the unclaimed estate first to the father as the grantor, or to the ancestral estate in the event the child passes after the father. Looking at and comparing the death certificate with the birth certificate, we can see the two documents share some similarities. As with the birth certificate, the death certificate employs similar conspicuous writing at the top of the document. The use of certificate here again tells the reviewer that the document is a written assurance or official representation that some act has or has not been done, or some event occurred, or some legal formality been complied with. Also, a written assurance made or issuing from some court and designated as a notice of things done therein. Black's Law 4th at PG 285. The next similarity is that the death certificate, like the birth certificate, is executed with two witnesses, making it a common law deed. Given this similarity, and that this supports the conclusion the death certificate is a deed, the purpose and effect of this deed is clearly one of defeasance. The next similarity is that, like the birth certificate, the death certificate records or attempts to record the name of both the father and mother. However, as with the birth certificate, the death certificate refers to the maiden name of the mother as opposed to her married name. As the myths surrounding the maiden name were addressed and dispelled in a different posted video, this will not be repeated here. As the reference to the maiden name appears on the grant deed, that is, certificate of live birth, and the defeasible deed, that is the death certificate, there can only be one explanation for both occurrences. The reference to the name of the father of the child, and the reference to the maiden name of the mother, even though the woman is married, must necessarily operate to ensure proper accounting of all heirs to the ancestral or legacy estates of the mother and the father. Though the personal estate of the mother is brought under the estate of the man upon marriage, this cannot bring with it the ancestral or legacy estate on the mother's side, because the woman can only hold this as an administrator until the rightful and lawful male heir can assume the role of executor of the estate by the law of ascension. Therefore, the maiden name of the mother is found on the birth certificate in order to ensure the proper and lawful division of the estates is maintained and preserved for when a lawful claim of right is made. Additionally, and for the same reason, the maiden name of the mother is found on the death certificate. However, where the use of the maiden name of the mother on the birth certificate operates to reserve the claim of the child to the ancestral or legacy estates, the use of the maiden name of the mother on the death certificate reverts any such claim evidenced by the birth certificate back to the ancestral or legacy estates, or by other terms, clears the cloud of title to the ancestral or legacy estates, which otherwise would cloud title to the estate. A cloud on title means an outstanding claim or encumbrance which, if valid, would affect or impair the title of the owner of a particular estate, and on its face has that effect but can be shown by extrinsic proof to be invalid or inapplicable to the estate in question. Black's Law, 4th at 332, emphasis added. The last similarity is the reference to the place of birth. This writer believes this simply references the place or location of the estate, and is thus used instead of blatant reference to the birth certificate number in the death certificate. This may be due to an attempt by lawyers to conceal the truth of what is actually occurring, which has ancient roots, see Matthew 23:13-15, Luke 11:52, or it may be done in this manner as the birth certificate is held in trust by the county clerk, who is an officer of arms and likely a herald, and therefore acts as notification to the trustee of both the event of formation, the birth certificate, and the event of termination, the death certificate, of the trust by operation of law. Before concluding this presentation, it is wise to explain what the term office of arms means, in order to ensure a more perfect comprehension. An officer of arms is a person appointed by the sovereign or state with authority to perform one or more of the following functions: to control and initiate armorial matters, to arrange and participate in ceremonies of state, to conserve and interpret heraldic and genealogical records. As regards the birth and death certificates, the first function, to control and initiate armorial matters, and the last function, to conserve and interpret heraldic and genealogical records, are applicable. Heraldic records appear to be a reference to the office of herald, which is associated with the acts of heraldry. Heraldry is the profession, study, or art of creating, granting, and blazoning arms, and ruling on questions of rank or protocol, as exercised by an officer of arms. American Heritage Dictionary of the English Language, 4th ed. 2000. Historically, it has been variously described as the shorthand of history. A Complete Guide to Heraldry, 1925, by Fox Davies. As we can see, the above similarities join the birth certificate or deed with the death certificate or deed of defeasance to preserve lawful title to the personal estate of the child, the ancestral or legacy estates, and to ensure the ascending of the rightful heir to the office of executor of the ancestral or legacy estates, does not suffer under cloud of title.